The 8 VIP officers charged in connection with the Johannesburg N1 highway assault have each been granted 10,000 Rand bail. Let's get an update. Zikhona Tshona standing by with a member of the National Prosecuting Authorities. Zikhona, good morning to you. A weak case presented before court. I think that's the sum total of what the magistrate had to spell out here. Are they proud of what they've done?
A weak and frail case, the magistrate told the court today in the state's arguments to have the 8 accused denied bail today. So several reasons given by the court. One is that the state has argued that one of its witnesses, the one who posted the video on social media, was sent a threatening message. The state also told the court last week that it's facing a challenge of tracing who the sender of this message was. The court last week put it to the state that this is crucial information that you are missing. You are saying that one of the reasons that the accused should not be granted bail is because you feel that one of your witnesses' life is at risk, or in fact his family's life is at risk because of this text, but you can't prove before court that the accused before court are linked to this SMS. And therefore, that's one of the reasons that the magistrate used to rather say that the state's argument was weak in this case, to say if you can't bring us the sender of the message, you have not proven that this court should deny the accused bail. The other reason is that we know that there is someone who took the video, a law-abiding citizen who was traveling along that road on that day, took the video. The state does not know the identity of that person. It's still to meet that person and then convince them to come and testify before the court. That person has already told the state witness whom they shared that video with that they are fearful. They do not want their identity to be made public. So the court said, until you've convinced the person who took the video that they will be able to come before this court and testify on your behalf of what they saw and relay, you basically give an account of what they saw that day. You can't keep the accused persons in court on a matter that you are still investigating, on a matter that you are still saying you are yet to convince a key witness. Because an eyewitness is a key witness in this matter. But talk to us more about this. Is the NPA spokesperson in Gauteng a weak case, a frail case? How are you feeling about this as the NPA?
Well, the test in these court proceedings is on a balance of probabilities. Hence, we requested the court to hear hearsay evidence, which is admissible in these proceedings. However, we do take the court's remarks in a positive light. Though as the state we were sitting with a predicament that information was made available that one of our witnesses received threats, and therefore it was incumbent on us to protect the witness and ensure that we enroll the matter, as the prerogative lies with the state. And the test the docket has passed is prospects of a successful prosecution. So yes, investigations are not yet concluded, but we were not going to wait for investigations to be concluded to enroll the matter, because already with what we have at hand, we believe that a court acting reasonably may return a verdict of guilt.
But the magistrate was very clear to say that this matter was brought prematurely, that the state actually needs to go back and do a thorough investigation.
Well, as I said, that the prerogative lies with the state, and with the information that we had at our disposal, we felt that the matter is ready to be enrolled. Yes, some matters are enrolled once investigations are finalized. So each and every criminal case has its own dynamics, and it will differ according to circumstances and merits. So in this instance, Zikhona, as they say in Sotho, ke kgomo ya moshate. So we had to act on the information that we received to ensure that we promote the protection of the witnesses that must still come and testify in this matter.
Would you say then that you acted on public pressure in this case?
The guiding factor in enrolling any matter is evidential material contained in the docket, whether it is sufficient enough to pass judicial muster. It has nothing to do with the pressure that is received from the public. Yes, in taking such a decision, we would obviously consider the interest of justice as well as the interest of society. However, the guiding factor will always remain evidential material contained in the docket.
All right, the NPA, they're saying lessons learned from that judgment today, but they still strongly believe that they have strong evidence against the accused and believe that going forward they'll be able to prove that before a court.
Zikhona, Tshona live for us there at the Randburg Magistrates Court. Thank you very much.